All right, everybody. So we're live on a few different platforms, 4 platforms here, and we don't want to talk real long tonight, but we got some things we want to talk about. So let's go back to the basics again here real quick, okay? To the basics. Guys, the Constitution of the United States of America is the overarching requirements that every state must follow. The states, they gave up their sovereignty to join the Union and subject themselves to the supremacy of the Constitution of the United States of America. That's a fact. No one is arguing that, right? But the problem is that there's a hierarchy of laws, right? Just like there's a hierarchy in anything else, there's a hierarchy. There is the highest level and there's the lowest level, right? Constitution is the highest level. It's the strongest, most powerful. It's the highest law. No other law is above the Constitution besides God's law, but we're not going to go into that. We're talking about the political laws, right? So the Constitution is the highest law. Nothing else is above the Constitution of the United States of America. Okay? Below the Constitution would be statutes, would be ordinances, would be customs, would be case law, judge-made rulings. That's all below the Constitution, below it. So anything that is contrary to the Constitution of the United States of America would be unconstitutional, right? Anything. Doesn't matter what it is. An act of Congress that's in conflict with the Constitution is unconstitutional. A judge-made ruling that's not in agreement with the Constitution is unconstitutional. Okay? So what we have to remember, and what you guys need to consider as we go into this here, because there's a lot of attacks on this from a lot of different perspectives, right? Some people are saying, oh, the states, they don't have to follow the Constitution. That is not an argument that's going to fly. It's not, right? Some other people are saying, oh yeah, but Hurtado versus California from 1884 says you don't get an indictment by a grand jury. That's not going to fly either. Because, once again, the judicial branch, judges cannot legislate. Judges cannot change the Constitution of the United States of America. The only thing that can change the Constitution of the United States of America is an authentic act of the people in accordance with the special amending procedure of Article 5. If you want to know how to change the Constitution, you go to Article 5 and it'll tell you how to do it. And it doesn't have anything to do with the judge. Nothing. So when the Constitution of the United States of America, being the highest form of law, nothing above it, when it says that you must have an indictment by a grand jury before holding someone over for a capital or an impus crime, then the answer is that anything that says that you don't have to have an indictment would be unconstitutional, because it would be contrary to the Constitution. So don't let some of this narrative seep in. Don't let it make you nervous. Don't let it upset you, because they can't win. When we get up to the highest form of law and when we stand on it, nothing can fight it. Nothing can disagree with it without being unconstitutional. All right? So let's talk about Hurtado versus California real quick. So in 1884, the United States Supreme Court came out under the Waite Court, and they said, you don't have to do an indictment by a grand jury. States don't have to do it. Now let's look at the history behind that. Let's just understand the history. The reason why the court made that decision was, one, there was a case in 1833 called Barron versus Baltimore, which the Supreme Court of the United States said that the Bill of Rights, which are the first 10 amendments to the Constitution, that those are not a restriction against the state governments. They are only a restriction against the federal government. In other words, only the federal government has to give you the rights that are specifically enumerated within the Bill of Rights. Your freedom of speech, your freedom of religion, your freedom of press, your right to a grand jury, right? Your right to a jury trial. All these things They're written in the Constitution for all to see. The Supreme Court came out in 1833 and said, states, you don't have to do that. States, you're not bound by the things that the Constitution restricts you from being able to do. Right? Now, why did the Supreme Court make that decision? They didn't make that decision because it was the right decision. They made that decision because 6 months after Barron versus Baltimore and the ruling was put into place, the federal government established the first national bank. All right? The first national bank. Now, what does that have to do with Barron versus Baltimore? Well, because the federal government knew that the moment that they established that first national bank, that the states were going to sue. The people of the United States, we knew that debt was the quickest and easiest way to enslave a nation. We knew it from our own history. I mean, this is what led to the Revolutionary War, taxation without representation, right? The stamp tax. So the federal government wanted to be able to establish that national bank. They knew that the states were going to sue. So they had to make it so that you didn't have standing in federal court so that the states couldn't sue. And the way that they did it was in Barron versus Baltimore, they said, oh, the Constitution doesn't apply to you states. And in order to have a case in federal court, the law has to, you have to be directly impacted by the law. If you're not directly impacted by the law, you don't have standing, you can't bring a case. So when the Supreme Court in 1833 said, states, the Constitution doesn't apply to you, all that they were doing was eliminating standing, making it so that the states couldn't sue the moment that the federal government established that first national bank, which they did. That was a national bank that Andrew Jackson, President Jackson, ended up ultimately destroying. But that's the reason why the Supreme Court made that decision, Barron versus Baltimore. So let's look at the history once again. 1776, our country, our people, we come out, we say, we are now free. We have the right to say what we want, to think what we want, to worship how we want. We have the freedom to do that, right? It wasn't until 1925 that anyone was protected by anything contained within the Bill of Rights. And it was the freedom of speech. And it was a case called Gitlow versus New York. Gitlow versus New York. So if you can imagine, 1776 until 1925, no one was protected by the freedom of speech. No one was protected by the freedom of press or the freedom of religion. Because the Supreme Court of the United States said in 1833, states, you don't have to give the people of the United States the very rights that they guaranteed to themselves. This was a deceptive act by our Supreme Court in its very beginning, at its inception. And the problem is that in 1925, the Supreme Court of the United States came out in Gitlow versus New York and said, yep, freedom of speech is protected against interference by the states because it's codified in the Constitution's text, right? Because it's written in the text, it is protected against interference by the states because it's written in the Constitution's text. And you would think that as of that moment, all of the rights that are codified in the Constitution of the United States would be applicable, right? You would think, because they said, oh yeah, that's protected against interference by states because it's in the Constitution's text. But that's not how it worked. That's not what happened. That's not what happened. What happened was then they started what is called the incorporation doctrine. And the Supreme Court of the United States started slowly incorporating one at a time each of the rights that are specifically enumerated within the Bill of Rights. One at a time. Such as 1966, Miranda versus Arizona, right? Which is the right to not self-incriminate under the Fifth Amendment. Or such as in 1969, Duncan versus Louisiana, right? And the right to a jury trial. So 1925, for the first time in the history of our country, anyone was protected by any of the rights contained within the Bill of Rights. Then the court started slowly incorporating one case at a time each of those rights all the way up until 2019. And the 2019 was Timbs versus Indiana, Timbs versus Indiana. And that was the last provision of the Bill of Rights to be incorporated, the last one. And it was the excessive fines clause of the Eighth Amendment, right? Well, the Supreme Court of the United States, they came out and they said in that particular ruling, 2019, it was a unanimous decision, you guys, unanimous. And 6 of the same justices that we're still dealing with today on today's court were the justices that made the decision. What they said is that they said that the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference by the states because of the codification in the Constitution's text. So once again, if it's written in the text of the Constitution, that is at a minimum what every single United States citizen is guaranteed under the Privileges and Immunities Clause of the 14th Amendment. You see, guys, there's 5 different provisions within the 14th Amendment. Traditionally, the court has used the Due Process Clause of the 14th Amendment to determine incorporation, right? No state shall deprive any person due process of law, right? So they were using the Due Process Clause to determine whether or not you had a right guaranteed by the 14th Amendment and against interference. But the problem is that the Due Process Clause was the incorrect provision to use. It wasn't the right one. And that's why I'm not using the Due Process Clause. I'm using the Privileges and Immunities Clause, right? Big difference, you guys, big difference. And even the court, even Justice Thomas acknowledged in 2019 in Timms versus Indiana that the Privileges and Immunities Clause is a much better provision to use for incorporation. Because before, the court was just picking and choosing. They're like, well, yeah, that's not part of due process. You know, we don't have to do that because that's not part of due process. And so the court was able to, to just say whatever they wanted. If they didn't want it, then they wouldn't allow it. Oh, that's not part of due process protected under the 14th Amendment. And that's what they did in Hurtado, right? Hurtado versus California from 1884. Hurtado versus California is the ruling from the United States Supreme Court where they came out and said, yeah, you don't get an indictment by a grand jury. You don't get it because it's not protected by the Due Process Clause of the 14th Amendment. But they pointed to Barron versus Baltimore, which makes Hurtado what's called progeny, right? It's a descending case. It's a descendant of Barron. So they pointed to Barron and they said, Barron says that you don't get it. And then Hurtado comes forward in 1884 and says, hey, I'm entitled to an indictment by a grand jury. Bear in mind, this is before incorporation doctrine even started. Because incorporation didn't start until 1925. So 1884, Hurtado versus California comes forward. Supreme Court says, oh no, that's not protected by the 14th Amendment. You don't get it. And thus, today, no one gets the grand jury clause. It's not protected because it hasn't been incorporated yet. Guys, incorporation didn't start until 1925. So of course in 1884, it couldn't have been incorporated because it has never been challenged since incorporation began. But that's the reason why Hurtado isn't valid. Because once again, the Supreme Court of the United States has no authority to amend the Constitution of the United States. And if the Constitution says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, well, that's clear. You got to have it. You can't go without it. If you do, that would be unconstitutional. So when the Supreme Court of the United States comes out and says, state of California, you don't have to do an indictment by a grand jury in Hurtado versus California, what happened there is that the Supreme Court of the United States amended the Constitution of the United States through judicial fiat, through a judicial ruling, and when they did, that amendment is unconstitutional because it was not done in accordance with the special amending procedure of Article 5. The Supreme Court of the United States is responsible for the situation that we're in. They are the reason why there's 700,000 people currently in prison here in America on direct facial constitutional violations. That's not a difficult thing to understand. But what we want, what I want to do, what I'm trying to do is I'm trying to remove Barron versus Baltimore. That's what I'm attacking, right? Because once again, 1925, freedom of speech suddenly protected. Then then through the incorporation, we get all these other ones. The thing about it is that right now, today, there's one provision left to be incorporated. All the rest of them have been incorporated. Every other one has been incorporated except for the grand jury clause of the Fifth Amendment. It's the last one to be incorporated. Once we incorporate the grand jury clause of the Fifth Amendment, then for the first time in the history of this country, every single person will be protected by every single right secured by and enumerated in the Constitution of the United States of America, regardless of where they choose to reside within the jurisdiction of the United States. This is the biggest case that you can even imagine, because what we get to do is we get to attack, first off, Hurtado versus California. Because Hurtado, the Supreme Court of the United States, said, yeah, California, you don't have to do what the Constitution says you have to do. Right? They amended it. But through Hurtado, we get to attack Barron. Because once we overturn Hurtado, once we technically overrule it and we say, you know what, you didn't have the authority to amend the Constitution of the Supreme Court of the United States, then we get to go after Barron. Because Barron has always been unconstitutional, but we had to get all of these rights enumerated, that were enumerated, incorporated. Because now, now we can go back to Barron versus Baltimore. We can say, look, every one of those rights contained within the Constitution, within the Bill of Rights, every one of those enumerated rights, they were always enforceable. They were always a restriction against the state, because they were always codified in the Constitution's text. That's what we have. That's what we're looking at. That's how big of a case this is that we get to go back to 1833 and Barron versus Baltimore, and we get to say to the United States Supreme Court, you guys introduced fraud into the system. And what does fraud do? It vitiates any action of a court. And until the court removes the fraud completely, nothing that the court does is valid. And if it's the highest court in the land that introduced the fraud, then every court in the land has the fraud permeated into it. The Supreme Court of the United States has to direct all these courts to act in a constitutional manner consistent with the obligations that they have codified in the Constitution of the United States. And until they do so, nothing that any court in this country does is valid. Nothing. Because it's all produced from fraud perpetrated by the highest court in the land. They introduced it in 1833. That's everything. Everything that's been done. All cases that are progeny to Barron would all be eviscerated. It'd be vitiated. They would not exist anymore. Right? We don't got to challenge the judgments. We don't got to. All we got to do is attack the highest case, the first case where the fraud was introduced. And once we attack it, once we destroy it because of the fraud and unlawful introduction of law by an agent, by a branch of government that has no authority to create law, when they did that, everything that every court across this country is doing is based upon the fraud introduced by the highest court in the land. That's what we get to do. That's why this is such a big deal, you guys. This is huge. Because every single criminal case, every single slave since 1833, their judgments are void. Every single one of them. Because they're all progeny to the decision made by the Supreme Court of the United States. So if the Supreme Court made a ruling and said, you know what, states, you don't got to do what the Constitution of the United States says you have to do, like they did in 1833, then that means that they introduced fraud into the system because they removed the Constitution of the United States and instead put into place their ruling. And they called their ruling law, case law. They told all the states, you don't have to follow the Constitution. We make the law, not the people of the United States. We make the law, and we have the authority to amend the Constitution in other than lawful manner. They introduced that fraud. And now, because the Supreme Court of the United States directs all the courts within the nation on what they must do, right? Then that means that every single court in the nation is following the fraud introduced by the Supreme Court. Once again, guys, fraud vitiates any action. And until the fraud is removed, nothing that a court does is valid. Let's take another look at Hurtado here, right? Because once again, I'm not going to argue the validity of the 14th Amendment. I'm not going to argue that with anybody. But I'm going to tell you guys that if it was not ratified lawfully, we still win. If it was ratified lawfully, we win. Either way, we win. The reason why is because the 14th Amendment, we are using the Privileges and Immunities Clause of the 14th Amendment. That's what we're using. Not the Due Process Clause, the Privileges and Immunities Clause. Because what it says that no state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens. Right? Abridge means to reduce, diminish, take away. Right? So you can't reduce, diminish, or take away any of the privileges and immunities of United States citizens. 2019, the Supreme Court came out, Timms versus Indiana, and they said that the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference by the states because they're codified in the Constitution's text. The Supreme Court of the United States said that the privileges and immunities of United States citizens are whatever is written in the Constitution and the Bill of Rights. That's what they said. Unanimous decision. 6 of the same justices that we're dealing with right now today said in 2019 that you get at a minimum whatever is in the Bill of Rights. So what are they going to say about this? What are they going to say about, because this is clearly enumerated within the Bill of Rights. Clause 1 of Amendment 5, you can't hold someone over for a capital or an infamous crime without an indictment by a grand jury. Supreme Court, what are you going to do? 6 of you already made a decision, a unanimous decision, said whatever is written in the first 10 amendments to the Constitution is at a minimum what you have to be given against interference by the states. So that's where we're at, right? We'll have this sewn up through the Privileges and Immunities Clause. But the problem is that we got to get heard. We have to get heard. They're ignoring us. They don't want to make this decision. They've been caught with their hand in the cookie jar, and now they're just kind of hoping and praying that this isn't going to take action. That this isn't going to start momentum. Right? That's their only play. That's the only play that they have. Now, if the 14th Amendment wasn't properly ratified, and I believe it was, but nonetheless, if it was not, we still win. The reason why is because the 14th Amendment was adopted and ratified in 1868. 1882 was Hurtado versus California. Hurtado versus California came after the 14th Amendment. And Hurtado versus California relied upon Clause 1 of the 14th Amendment in order to make that decision. Right? Waite and his court relied upon the first clause, which says that all persons born or naturalized in the United States shall be citizens of both the United States and of the state in which they reside. Chief Justice Waite relied upon Clause 1 of the 14th Amendment in order to establish Hurtado versus California, which means that if the 14th Amendment wasn't ratified, if it's not valid, then guess what? Hurtado is void because it relied upon the 14th Amendment to be established for them to make that decision. And it came after the 14th Amendment. So either one, Hurtado doesn't exist, which means that this has never been litigated before. They can't point us to Hurtado and say, oh, you don't get it because of Hurtado anymore, because Hurtado's not valid, which means that this is an original civil action, and they can't refuse it because this has never been litigated. They can't point to Hurtado anymore, right? Or or we win because the Privileges and Immunities Clause and the decision that they made in 2019. Either way, we're going to win. Either way, we're all right. But the key is we've got to make enough noise now to be heard. Make them so that they can't ignore us any longer. That's key right now.
Okay.
Yeah.
I have questions.
Okay.
The jurisdictions, talking about law and equity and then maritime, can you go over that?
I have a lot of video out on that. I don't really want to go into that right now. Guys, I don't care which jurisdiction we operate in. I honestly don't. You know, I know that we're in Admiralty. We all know that we're in Admiralty. That's why we don't get a jury trial. And I have a video that's out there that talks about, you know, about the fact that the moment you infringe a flag, you place the fringe around a flag, that your right to trial by jury goes away because it's been infringed. That's why most state constitutions says the trial by jury shall not be infringed, because our founders and forefathers knew that the moment you place a fringe around a flag, you don't have a trial by jury anymore because it's been infringed. That's where that word comes from. The reason why I don't really care is because in Admiralty, it's contract law, and we win in contract law, right? We win because the Constitution is a contract, and as a contract, just like any other contract, show me where in the four corners of the contract that you can do something or forbear from doing something, and if you can't, I win. Contract law is really easy, right? If the way in which the contract is formed is illegal, then the contract formed becomes illegal. So, you know, a lot of people talk about how there's there's a couple different constitutions out there. No, there's not. Because you can't breach the terms of one contract in order to enter into a new contract, because by the breach of the first contract, you'll nullify the second contract. So the Constitution of the United States was the contract that was created by the people, given to our government, established by our government, and said, here, govern us in accordance with this contract, with these procedures, right? And if you don't, then you are acting unlawful. You're breaching your contract. You're breaching the terms of contract. So if there is a second constitution that was established in 1871 or any other one, then the problem is that it's not valid. Because in order to establish a new constitution, a new contract, they would have to breach the terms of the first contract. And by the breach of the first contract, you would nullify the second. So in simple contract terms, the only way you can change the Constitution of the United States of America is in accordance with Article 5 and the special amending procedure. There's no other way to do it. No other way. So anybody that talks about other constitutions, they don't understand that contract cannot be breached. The terms of the contract can't be breached, because if you breach the terms of the Constitution, if you amend the Constitution in other than lawful manner, then you have established nothing at all, right? So there isn't a second constitution, right? There's one constitution, and there's one constitution that says this is the way we change it. And if government chooses to change it any other way, that is an act of sedition, because the contract terms are contained within Article 5, the way in which to change it. So we got to rely upon the highest form of law. You have to. Constitution of the United States, highest form of law. Anything that's not the Constitution is unconstitutional. Simply by virtue of the fact that it's not the Constitution makes it unconstitutional. So,
And unconstitutional is illegal.
Unconstitutional is not valid, guys. It's not legal. It's not legal, right? Or it's so there's a difference between legal and lawful. I'll give you guys that. It's not lawful, because the only thing that's lawful is in accordance with the law. Anything that's not full of law would be unlawful. So it may be legal, but it's not lawful, right? So take for instance Article 3, right? Article 3, Section 2, the original jurisdiction of the Supreme Court. You guys know that that's what we're challenging. That's what we're bringing up. You guys know that That's the big part of our argument. So when the Constitution of the United States of America, when it says that in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. That means that any time that a state is a party in any cause, criminal or civil, that the Supreme Court of the United States is the court that acts first, the original court. No other court in the country can act before the court that has original jurisdiction. That's what it means, original jurisdiction, right? So the Constitution also says that in all other cases of equity in law, the Supreme Court shall have appellate jurisdiction. So we're all very familiar with the Supreme Court's appellate jurisdiction because we appeal to it every day, right? We believe that's the last court to go to. It's the court of last resort. We go to it last as an appellate court. But we don't know anything about its original jurisdiction because the last time original jurisdiction was effectively invoked was in 1890. Because the United States Congress created an act that technically prevented us from being able to use it. And that's known as the Judicial Reform Act of 1925. So what the Judicial Reform Act of 1925 said is it made the United States Supreme Court and all the state Supreme Courts all courts of discretion, right? Discretion. So they can use their discretion to decide whether to hear a case or not hear a case. We all believe that the Supreme Court of the United States is a court of discretion because that's all we've ever experienced. We haven't experienced anything else. That's all we know because that's all that we've ever had within our lifetime. That's all we've ever seen because in 1925, the United States Congress said, oh, they're a court of discretion now. They can pick and choose which case they want to hear or not hear. Okay? Well, the problem is, remember, even acts of Congress must comply with the Constitution or else they are unconstitutional. So the Supreme Court of the United States can be a court of discretion so long as a state is not named a party. If a state is named a party, they can't use discretion because original jurisdiction has been assigned to that court, right? Because the Constitution created the obligation. And you remember, guys, you can never, ever, ever use discretion with regard to one's obligations. Obligations must be performed. Otherwise, you are using your discretion abusively to break the law. So you can never use discretion with regard to one's obligations. Obligations must be performed. Otherwise, you're using your discretion abusively to break the law. And you cannot do that. So, in 1925, the United States Congress came out and said, Supreme Court, you're now a court of discretion. And we all believe that they're a court of discretion. But if the court uses discretion to say we're not going to hear a case once original jurisdiction is invoked, then that is an abuse of discretion in order to break the law, break the Constitution. Supreme Court can't do that. They have no authority to. And Congress doesn't have the authority to direct them to break the law, right? Because ignorance of law is no excuse for having violated it. So when you consider the law, once again, hierarchy, Constitution is the only thing that matters. So when you guys go out there, right, and you want to formulate an argument for a case or whatever, don't use anything but the Constitution. Because the state statute is inferior to the Constitution. A judge-made ruling is inferior to the Constitution. Right? A treaty is inferior to the Constitution. It's all inferior. So if you want to win an argument, just use the Constitution. In all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. When a state says to you, yeah, but we have statutory jurisdiction, you say, no. Constitution says in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. And they say, yeah, but Title 28 subsection 1331 says that the district court has jurisdiction. And you say, no. Constitution says in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. They want to draw you off of the Constitution into an inferior law. They want to point you to Hurtado versus California from 1884 and say, you don't get it because of this, right? And 90% of the people are going to read that and say, oh, I don't get it, right? Oh, what Tanawah was saying is bullshit because the Supreme Court said, that you don't get it. But you guys, you're going to the lowest form of law. It's not even law. It's a ruling made by a body of men that has no authority to create law. So when you go to that and you say, oh, you don't get it because of this, I'm going to say to you, read the Constitution because it says you do get it, right? I'm going to draw you back up. You just keep on going back up there, right? So the Constitution of the United States is a contract. Going back to admiralty law, right? And so in contract law, the easiest and simplest way to determine whether or not someone's bound to do something, such as the judges and supremacy clause that the judges in every state shall be bound thereby anything in the Constitution or laws of any states contrary notwithstanding. So the term bound is very, very important because a duty is defined as something that, an obligation is defined as something that a person is bound to do or forbear from doing. Okay? So if the judges are bound to do something, an obligation is something that a person is bound to do or forbear from doing. So that means that the judges have an obligation because they're bound. They have an obligation. Okay? So an obligation can be seen from two different perspectives. Okay? From the one bound, the obligation is a duty. From the one entitled, the obligation is a right. So every obligation creates a duty and a right. It preserves a right. What is an obligation? It's a law. A law. Every law is nothing more than an obligation. Laws create obligations. So I have an obligation to not unalive someone. I have an obligation to not assault someone. I have an obligation to not steal from someone. The law creates the obligation. Thou shalt not steal is an obligation. Okay? And it establishes a law that says you don't steal from someone. Therefore, when you break the law and steal from someone, then their right to not have their property stolen has been violated. But it's not violated until someone breaks the law. So this is extremely important because that's what the Constitution is. Constitution is a law. It creates obligations. Okay, those obligations establish duties that the judges are bound to do. Which means that if a judge breaches their obligation and fails to make sure that there's an indictment by a grand jury in place, then your right to not have have a grand jury has been violated, but it doesn't happen until the judge breaches the law, breaks the law, and thus violates your right. Because the judges are bound thereby anything in the Constitution or laws of any states contrary notwithstanding. So, in admiralty law, again, the easiest way to determine whether or not there's a breach of contract is a four corners test. Show me where in the four corners of the contract it says that you can do something or forbear from doing something. So our question in admiralty law is going to be, or in admiralty jurisdiction is, Supreme Court of the United States, show me where in the four corners of the Constitution it says that you don't have to have an indictment by a grand jury. Because I'm going to show you where it says you do. And if I'm able to show that you do, in admiralty law, I win. Common law is not as easy. Because common law is made up of judge-made rulings. I don't want to argue in common law. I don't want to go there. Because common law is made up of judge-made rulings. And so the fact that we're in admiralty jurisdiction is fine by me. It makes it a whole lot easier because I can now fight them from the contract. The contract says you got to have it, you don't have it. Great, we're good.
So does that still apply with the Seventh Amendment and the trial by jury in excess of $20, and that's common law? And how do people get a trial by jury if we're not still in common law?
So the problem is, again, is that the only reason why these judges are doing the things they're doing is because they're permitted to do it. They have a predetermined outcome. They want to achieve their predetermined outcome, and they're going to do whatever they got to do to make it there, right? You're entitled to a jury trial. In all cases of equity, where in controversy of over $20, you're entitled to it. No state can say we're not going to do it. Let's remember jurisdiction here, right? Because we the people, we created in our sovereignty the Constitution of the United States of America. We created that. That's what we created. That we're the creator because we were sovereign. The moment we won the war, we were sovereign, and we were able to then, decide how we want to live, our future, how we want things to be. So we, in our sovereignty, created the Constitution of the United States of America. The Constitution then creates jurisdiction, which is the authority for a court to speak the law. Absent jurisdiction, the court has no authority to be a court. Because in order to be a court, you must have jurisdiction. And jurisdiction is created by statute, right? So, we the people in our sovereignty created Constitution. Constitution created jurisdiction. Jurisdiction then creates the court, and then the court creates the court's agent. People are the highest on the totem pole. We fight at the level of the Constitution. The lowest level is the judge or the agent, and they fight with judge-made rulings. They're going to the lowest form of law to fight us at the highest form of law, and yet we are the highest on the totem pole. We are the sovereign, not the judges. So, you just died. You can unplug. No, you can't. One second, guys, hang on.
It's okay.
Well, unplug your phone. Use that one right there. So we the people in our sovereignty, we created a Constitution. So no court can be a court without jurisdiction. Which means that when a court doesn't follow the Constitution, it of course loses jurisdiction. We all know that. Now, the Supreme Court came out last year. It was, I think, January of last year. And they said in January of last year, I don't remember the case, guys. They said that the difference between a jurisdictional rule and a claims processing rule, which a claims processing rule is an appeal. You're appealing something. You're filing a claim, right? So the difference between a jurisdictional rule and a claims processing rule is that a jurisdictional rule can never be waived. It can never be forfeited because it comes as a first duty to court. Okay? First duty to court. It can never be waived, can never be forfeited. Because before that court calls you in to the courtroom, it has to first have jurisdiction. And if the court doesn't have jurisdiction, then it has no authority to speak the law. That's why, some people are saying, yeah, but when you walk into that court, you grant that court jurisdiction. No, you don't. That court can't be a court without jurisdiction. Therefore, you walking into the courtroom, it doesn't matter. That's why the Supreme Court said just last year that a jurisdictional rule can never be waived, can never be forfeited, because it's a first duty of the court. Before the court can be a court, it must have jurisdiction. Absent jurisdiction, anything that court does is not valid. even you walking into it doesn't subject yourself to their jurisdiction, because there is no jurisdiction. Jurisdiction is a creation of statute. It's a creation of constitution. Absent jurisdiction has no authority. So to answer your question, I don't know how we're going to get them to do it, but they absolutely have to do it, or else what they're doing is unconstitutional. Because the Constitution says in all matters over $20, you have to have a jury trial. Now, why was that, you guys? Why was that? It was because we were dealing with a king, right? With England, we were dealing with a king, and that king had his agents, prosecutors and judges, and that king was taxing us, right? Taxation without representation, the stamp tax. That king was taxing us. We didn't want to be taxed, right? And so the Constitution in Article 1, we delegated, the only branch of government that we delegated the authority to tax the people is the legislative branch, right? Only the people can choose to tax or create a tax against the people. They're the only ones. So, for instance, in the case of an indictment by a grand jury, right? If the prosecutor brings information, that information is then billing you, right? It's a bill. They're billing you and they're charging you, right? It's a debt. It's a tax. But it's a tax that's created by a branch of government that has no authority to tax. So when a judge makes a decision to tax you, such as child support or in the case of these three-letter agencies like the IRS, right? That would be taxation without representation. That would be a tax created by a branch of government that has no authority to tax the people. But you see, in a courtroom, when you walk into that courtroom, all three branches of government exist within there. The judge is the judicial. The prosecutor is the executive. And the legislative is represented by the jury. So if a jury doesn't make a decision to tax you, then that would mean that tax is coming from a branch of government that does not have the constituted authority to be able to create a tax. Only the legislative branch has the authority to tax the people. So if there's not a jury, then that would be a tax created against an individual or people by a branch of government that has no authority to do it. They have to have a jury trial. Otherwise, we have arbitrary and capricious acts by agents of whatever. So.
Okay. Hold on. Finding more questions.
So guys, while she's looking here, we're not heading out. Okay, so tomorrow morning we're starting this 40 days. You guys know what we're doing now. We're serving as many of these city councils, county commissioners as possible. If you guys still aren't clear what I'm doing, go watch some of my videos from the last couple of days. You guys will see. But it costs a lot of money to do this, guys. A lot of money. All right? And so we need your support, guys. We need you guys to step up and help fund this so we can make this happen. All right? So if you guys want to support this, you guys want to donate, you guys want to see us be successful, we're starting tomorrow morning. Not going to say where we're at. We're not going to give advance notice to where we're at. You guys will all see the video after we're done serving. We will get all the videos posted, but for the next 40 days, we're not going to be telling people where we're at, right? This isn't about that. This is about simply getting a job done. And that's what we're going to do. We're going to get the job done. You guys will have the video. You guys will know where we're at. But bear in mind that if we only serve one city council, one county commissioner within the state, it's okay, right? It's okay. We don't have to come to every single city. We don't have to come to every single county. We want as many of these served as possible, but us too, there's only so much that we're going to be able to do over these next 40 days. We've got a lot of people that are stepping up, wanting to help do a service. That's awesome. Thank you guys so much. You guys are going to be instrumental in this. But again, what we are doing now is we are bringing a whole lot of attention to this, right? We want to make sure that when that Supreme Court of the United States returns from this summer recess, that they return to a shitstorm that's bigger than this country has ever seen. Because every single time we go out and we inform a city council that they are committing treason and paying for violations of the Constitution, that's raising red flags, right? And every time we go to a county and we say, all these people that you are housing in these jails is all unconstitutional, that's raising red flags, right? And the more we get out there and the more we serve, the more we inform of this, the more noise we're going to have to return to Washington, D.C. And hopefully this time they won't be able to ignore this. That's the whole point here is we just need to make as much noise as possible and hit them with as many little fires as possible. Because remember, Sun Tzu said in the book, The Art of War, he said that the first step to being victorious is you must break up the alliances and pit them against each other, right? So the first step to victory is we got to break up the alliances between the three branches of government, and we have to pit them against each other. And remember, I did that last year pretty effectively with the attorney generals and the Supreme Courts. Because when I went out and I served the attorney generals, I said, I said during that narrative, I said, it's the prosecutor's fault. They are choosing the incorrect charging instrument. They're bringing it forward. Judges, you're culpable in it because you're not making sure that the grand jury's in place, but it's not your fault. It's the prosecutors that are doing it. And what happened then? We got Chevron, right? Chevron was the Supreme Court of the United States pointing their finger at the executive branch prosecutors and saying, you guys are going to take the fall for this because you guys don't get to create policy and go out and enforce it as though it's law, right? If you're not clear as to whether or not you're supposed to have an indictment by a grand jury, then you need to go and, ask those that are able to lawfully amend the law or get clarification from them. You can't go out and enforce it. That was effective, right? That's the reason why Chevron was overturned, was because the judicial branch was placing the blame onto the executive branch because I went out and I served all the attorney generals. So after serving the attorney generals, then we go into Chevron, which was June 28th. I finished serving on June 6th of last year, all the attorney generals. And then June 28th, we get the Chevron ruling. And that was, again, the judicial branch point them saying, taking the narrative, the bait that I fed him, right? And saying, yeah, you guys have been bringing us the wrong charging instrument. We're no longer going to participate in this shit. But then what happened was then I went out and I served the state Supreme Courts. Served all of them. But I changed the narrative, you guys. I changed the narrative because I finished serving the state Supreme Courts on September 6th then. But I changed the narrative because what I kept saying then was, actually, the truth is that prosecutors, yeah, you're bringing the incorrect charging instrument. You're not following the law. That is correct. But the Constitution doesn't say that no person shall be charged by information, for a capital or crime. It says no person shall be held to answer. Held to answer. That's what the Constitution says. And who makes the decision to hold someone over? Well, that'd be the judge, not the prosecutor. Prosecutor can bring the incorrect charging instrument, right? But it's up to the judge to make sure the proper documentation is in place before they order someone to be held over, because it's the judge that makes that decision, not the prosecutor. So the truth is that it's the judge that breaks the law. Prosecutors, you guys are culpable in it, right? You guys are negligent. You guys are certainly a co-conspirator because you guys are bringing the incorrect charging instrument. But the crime isn't committed until someone is ordered to be held to answer for an IPS crime without an indictment by a grand jury. And that crime occurs the moment the judge commits it. So I changed the narrative. And that pitted those two branches against each other, right? Because after I finished serving, then the DOJ memo comes out. The DOJ memo to Grassley that said, all you judges, you're all unconstitutional, right? That was the executive branch now pitting themselves against the judicial branch, saying, we're not going to take the fall for this shit. You guys are responsible for it. You're all acting unconstitutionally, right? So we're pitting those two branches against each other. We see the effects of what we did. But now we got to get the legislative branch, because they're standing back and saying, "Oh, this is too big of a deal. We don't want to get involved in this, right? We don't want anything to do with this because we're just happy making the money and doing whatever we're doing." So we have to now bring in the third branch of government and get them involved in the fight too. How do we do that? Because they're paying for the crimes, right? The judicial branch and the executive branch, they get paid by the legislative branch. So legislative branch, you can't just sit back and say, "Oh, I'm not going to deal with this. This is too big." No, because you're paying for the crimes to be committed. So legislative branch, judicial branch might, they might be, failing to make sure that the proper charging instrument is in place. And the executive branch, they may be choosing the incorrect charging instrument. But guess what, legislative branch? You're paying them to do it. If you weren't paying them, none of this would be done. Therefore, you're probably responsible for it, legislative branch. And now we're giving them an additional option. So which branch of government is going to take the fall for this? Because one of them's going to have to take the fall. But we need to get the oversight of the other two branches to figure out who that is. Who is really responsible for this? Is it the legislative branch? Is it the judicial branch? Is it the executive? One of the three branches is responsible for this, and we're creating the pressure to make them figure out who it is. Who's going to be responsible for it? Is it the one paying them to do the job? Is it the one doing the job improperly? Or is it the one just following orders and doing whatever the hell the judicial branch told them to do? Right? Like a sheep. So that's what we're doing. We've done the first two tours. Now we're going into the legislative branch. And now we're going out to these city councils because, again, if the police officers are out making an arrest because they were taught to do it unconstitutionally, and that's all they know is how to charge by information, because that's all they've ever known, well, it doesn't make it right. It makes it still unlawful, right? And as a result, if the city councils pay the police officers to do their job and they're breaking the law, they're violating the Constitution in their job, then that means city councils, you guys are responsible for it. We're going to go out and we're going to inform these city councils that they're paying for these crimes to be committed. We're going to go out and inform the county commissioners that they are housing people that have been unlawfully detained because the state didn't follow the proper rules in doing it.
Okay, I have a question.
Yeah.
Obviously, this has been going on for a long time. So who's going to hold these people accountable? Does that fall on us and people to come out? Is that what we're doing? Holding all of these people accountable through exposure?
So ultimately, the decision comes from the court, but the battle is fought in the opinion of the public. Right? The Supreme Court of the United States doesn't do anything until they get enough pressure from the public, and then they do it. Right? They won't do anything until they get pressure from the public. Right? And so that's why they keep us down like they do. That's why they're, they keep me down. They suppress things I'm doing, things I'm saying, because that's the only play they got. They don't want this information to spread, because if it does, then they're gonna have to fix the problem. They're just ignoring it. So, guys, like, I can't tell you who's going to enforce this, right? I can't tell you how that's going to work. All I can say is that we really only have two choices. One is, do we believe in the Constitution of the United States of America? Do we believe in it? Right? Do we believe in this nation? Do we believe in this country? Because if we do, then we can't just give up. We can't become cynical and say, okay, this will never work. It'll never happen. There's too much corruption. Because if that's the response that we have, then you guys, we've already lost this country, right? I mean, we should be fighting for this, because this is the only thing as an American that's worth fighting for. I mean, all I'm doing is I'm fighting for the Constitution of the United States. That is the only thing that makes America America. That's the only thing that made this union, right? That's what gives me my life, my freedom, my sustenance comes from that law. Without it, then what do we have left, you guys? We have 50 autonomous nations that are able to govern people however they see fit, arbitrarily. We don't have justice. We don't have equality. We don't have equity. I can't answer your question, you guys. All I can say is that I believe in America enough that I'm going to get out here and I'm going to figure out who's going to hold them accountable, because if we don't figure that out, then we lost this country, guys. We lost it. Okay, so either one, we believe in America. And if we do, then we know what we have to fight for. Because the only thing that makes America America is the Constitution of the United States of America. So yeah, there's a lot of corruption out there. There's a lot of bad characters that we're fighting. And you know what? A lot of them might be too tainted, but that's just something we're gonna figure out. I can't give you an answer. All I can say is that this is the only fight worth fighting for, guys.
Well, you did give us an answer.
It's the public, the people.
The public, yeah. Yep. Okay. There's not really any more questions. So, do you want to tell people how they can serve? And
Sure.
notice?
Yeah. So, guys, again, so over the next 40 days, what we're doing is we're going out and we're serving city councils and county commissioners. Again, why are we doing that? If anyone wants to, if anybody's curious, you can go out and you can look at my YouTube, Facebook, Instagram, TikTok. The videos are all out there. The best service, I think, was the city of Richmond, city of Fairfield, Virginia. I did that maybe a couple months ago. It was a good service. But again, so the cities, what they do is they formulate the budget for the police. Okay? So they pay the police, right? They pay it through the property tax that's collected. So if the police are not following the Constitution, if they're breaking the Constitution, then that means that the city council is paying for those crimes to be committed, because they're paying those people to do their job. Well, an emolument violation is when you pay someone to break the law. That's a crime. You can never pay someone to break the law. Okay? So if you do pay someone to break the law, then you are complicit in that crime, right? Just like if you hire someone to unalive someone, right? You are now a co-conspirator in that unaliving because you paid them to do it. So if the police are going out and they're arresting people without an indictment by a grand jury in accordance with the Constitution of the United States of America, then that means city councils, you are paying for that crime to occur. You are a co-conspirator in a deprivation of rights under color of law, right? Now, these city councils, they have no clue that they're doing it. They have no clue because nobody's told them. They're just oblivious, going about their business like the police officers going about their business, not even having any clue that they're doing anything wrong, because that's just the way they were taught to do it, because they've been doing it that way for so long. But again, what they do is they turn around, they go to the city attorney, they're like, well, hey, is he telling the truth? Is he right? And the city attorney's like, no, he's not right. Hurtado versus California says you don't have to do it, so go about your business. But once again, that attorney doesn't realize that you don't get to go to a judge-made ruling that amended the Constitution, because that's unconstitutional. These attorneys have no fucking clue what I'm talking about here. Like, they are brain dead to this to this fact that what you're relying upon is not law. A judge-made ruling, Hurtado versus California, is not law, even according to the Supreme Court of the United States in Norton versus Shelby County, that any unconstitutional law, be it an ordinance, statute, custom, regulation, is no law at all. It creates no office, provides no protection, it grants no immunity. It is as inoperable as though it never existed, right? Because it's always been unconstitutional. It's not unconstitutional from the moment that it's deemed such, but rather from the moment it was created, as though it was never created at all. So when the Supreme Court of the United States created a ruling in 1884 that is contrary to the Constitution, then that is unconstitutional, and then they called it law. Now Norton versus Shelby County says that any unconstitutional law is not unconstitutional from the moment that it's deemed such, but rather from the moment that it was created, as though it was never created at all. Hurtado versus California, we are to treat it as though it was never even created at all. No court is bound to enforce it. No person is bound to obey it. Yet these attorneys are like, yeah. So the city councils, they're going to have a real rude awakening as well if they continue to go to someone that does not understand law and claims to be an expert in it, and yet they don't know the law. Because I haven't met a single attorney yet that understands the law, because they don't understand the basic concept of Constitution is the highest law. Anything that's contrary to it is not law. Judges don't get to create law. That to us is a pretty simple concept, but for some reason, to these people that claim to be experts in the law, that is a concept that is totally foreign to them for whatever reason. But just because it's foreign to them doesn't make it lawful, doesn't make it valid. It still is unlawful. It still is sedition. And after having warned them and notified them and they continue to do it, then their ignorance and blindness is actually going to lead them into a very, very dark and dangerous place, because we know what the punishment for such action is. So the city councils pay for the police to do their job. If the police are breaking the Constitution because that's what they're trained to do, city councils pay for that. So what we're doing is we're going to city council meetings, right? And Jess is getting up there with the script, and she's saying that Clause 1 of Amendment 5 says you got to do this. State of whatever, you're doing this. Clearly you're doing something different than the Constitution, which means that what you're doing is unconstitutional. Then she's informing them that an emolument violation is when you pay someone to break the law. You can never pay someone to break the law. Therefore, city council, you either stop paying these people, or two, you direct them to act in a lawful manner consistent with their obligations codified in the Constitution of the United States. And if you don't, then criminal sanctions can be brought against you, right? Because having been notified of these unconstitutional acts, after having been notified of these crimes being committed by your police officers that you're paying, if you don't make this happen, then you are yourself engaged in the criminal conspiracy after being notified of these crimes. So that's the first thing. City councils. Every single city has a city council meeting. You can go in there. It has a hearing period, a public hearing. By federal law, they have to provide a public hearing. And what you would do is you would go in and you have 3 minutes to speak. Sometimes 2, sometimes 5. But they can't interrupt you. They can't stop you. They can't even rebut you, which is great for us, because that means that everything we say is going unrebutted. Because by law, they can't even comment. They can't even respond. So whatever we say is what is being heard, and they can't even say, oh no, you're wrong, because they can't by law even comment back. They can't even respond. So we're going in. First, Jess is providing the first 3 minutes, letting them know that what they're doing is unlawful, unconstitutional, putting them on notice, right? And then I'm stepping up and I'm doing another 3 or 4 minutes of whatever, giving them some clarification, letting them know that the law of criminal conspiracy for public officials says that any person who having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined to dispense the action. So upon being given notice that these crimes are being committed, if you fail to take action willfully or negligently, it doesn't matter, after having been provided notice, if you don't take action to correct these unlawful acts, then you yourself can be named as defendants in the action because you are a co-conspirator in it. Pretty simple, right? So that's the city council. The county commissioners, the reason why we're going to them is because they prepare the budget for the sheriff's department and they prepare the budget for the jail, right? So if the sheriff is going out and performing arrests on warrants because the judge gave them a warrant, but the judge relied upon the prosecutor who brought the incorrect charge and instrument, then that means that that sheriff is now implicated in it because that warrant isn't valid, because the moment that they go out and perform an arrest on someone without having a warrant that's based upon a lawful charge and instrument, then that sheriff is now negligent and engaged in the criminal conspiracy, because once again, willfully or negligent, if you breach a constitutional obligation, you're part of criminal conspiracy. So every sheriff across the whole country that is taking a warrant from a judge who issued that warrant based upon an information from a prosecutor who chose the incorrect charge and instrument in violation of the Constitution of the United States, that sheriff is now committing a crime. They're now a part of the criminal conspiracy, which means that the county is paying for those crimes to be committed because the county prepares the budget for the sheriffs. Now, if that sheriff arrests someone and takes them down to a county jail, puts them in a county jail, and holds them there, even though they don't have authority to hold them because they didn't have the proper documentation in place to make that arrest, then guess what? County is paying for someone to be unlawfully imprisoned, unlawfully detained, because the detainment derives from an unconstitutional act, right?
Does that work the same when they come into our homes and take our kids?
100%. But the problem is that is an incorporated right. It's not enumerated. Okay, so you remember going back to the beginning, I was talking about the Timms versus Indiana case, TIMBS versus Indiana. And what Timms versus Indiana said is it said that the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference by states because of their codification of the Constitution's text. Enumerated. That ruling that we are relying upon, that was a unanimous decision, 6 of the same justices that are on the court today, they said enumerated. They didn't say incorporated, they said enumerated. So if we want to rely upon Timms versus Indiana, then we have to use an enumerated constitutional right. Nowhere in the Constitution does it say that you have the right to a relationship with your child. Nowhere, right? Because the Constitution, that right, the right of intimate association was incorporated in 1984 by the Supreme Court. It is not enumerated. That's why we're using the indictment issue, because that is enumerated. Therefore, we can rely upon Timms versus Indiana and say, Supreme Court, you guys said, 6 of you said that at a minimum, the people of the United States gets whatever's there. Therefore, grand jury's there. Great, we won. Over, right? It's a very simple thing. But again, we can't argue an unenumerated right and rely upon Timms versus Indiana because it said enumerated rights, not unenumerated. So, for instance, you guys, you're all talking about your right to travel. You do have a right to travel. We all know that. You have the right to use your property without governmental interference. We all know that. But that's also not enumerated. Nowhere in the Constitution does it say that you have the right to travel. A lot of people say, oh yeah, it doesn't. Nowhere in the Constitution, and if anybody can show me some place in the Constitution where it's enumerated that says you have the right to travel, please, by all means, I would challenge you to show me where it says it, because it doesn't. Okay, that is an incorporated right, incorporated by the Supreme Court of the United States. That's fine. It is valid, incorporated, but it's not enumerated, right? You fight enumerated constitutional violations differently than unenumerated. We will get the right to travel protected along with the right of intimate association, the right of our family. All of these unenumerated rights we will be able to preserve through what we're doing with the enumerated right? Because ultimately we're going back to Barron versus Baltimore and we're holding them accountable for 243 years of unconstitutional acts. So yes, if you have the right to have an intimate familial relationship with your child without governmental interference, then when the state brought an agent through one of its agents, brought an accusation forward against you, right, through CPS, and then that judge decided to rely upon that CPS agent's actions to abuse his discretion to take your child, and then gives that order to a sheriff to go out and take that child, yes, absolutely. That sheriff is implicated in it because it all derives from something that the state can't do. If the right to intimate association is to be preserved by the Constitution incorporated in 1984, then that means that no state can create a law that would interfere with it, right? So county commissioners are implicated because they're paying for the sheriff's department who are going out and performing unconstitutional arrests on warrants, or they're taking children unconstitutionally, right? And then they're bringing them back to a county facility and housing them in that county facility. And so now county commissioners, you're all implicated in this because you're paying for that to happen. Not only that, but the court itself is a county court. So if the prosecutions and the convictions and all of these judicial proceedings are occurring within a county facility, right, and it's unconstitutional proceedings because it derives from an unconstitutional arrest, then once again, counties, you are implicated in it, right? You're implicated in it. One second, guys. I can plug my phone in here.
I can talk for a second. Can I talk for a second? Okay. I have some people on TikTok that were saying that they want to share and they want the script. So the Davenport, when we served, provided notice to Davenport, Iowa, that was the one that I read the script the best. So if you want to go back and look at that on either one of our social media sites, but if you go to justicewithoutlimits.org, that's the same handle as my TikTok, justicewithoutlimits.org, and that same script is there. It'll forward you to a Google Drive, and then you'll go on, and it's under nationwide service. You'll go in there, you'll see that it has two different scripts. One is a script that has some different texts and underlines to try to keep you in sync, and then the other one is just a plain text. And then you'll also see where it says the notice provided. So that's the notice that you'll print out. It's a 4-page printout. That is what I handed to the clerk at the end of the 3 minutes. And all of that was written by Tanawah. You don't have to do anything. You just print it out and hand it to them. Guys, what Tanawah was saying before about we the people, when someone asks who is actually going to hold these people accountable, and it is us, this is one of the ways that we're going to do it. So what we want to do, what I envision, I'm going to go a little bit down a rabbit hole here. If you're familiar with the montage of news outlets, okay, the local news outlets, when they put a montage together and every news outlet across the country is saying the exact same thing on the exact same day at the same time, that's what I want to do. So we need 360 people to commit to serving 6 counties. It doesn't have to be the county that you are actively involved in or litigating in, but we need 360 people to commit to serving 6 counties. We will cross the threshold at that point of having 2/3 of the counties served. There's only 3,143 counties in the United States. So we can do that. I need to have direct contact with you, and it's really difficult to just go through the messages on Facebook, or if you guys are sending me messages on TikTok, guys, I have 722 messages right now that I haven't had a chance to check. So What we need you to do is go to my Facebook page. I'm going to pin the Zoom link at the top of my Facebook page every Thursday from 8:30 to 9:30 Eastern Time. We're having a Zoom and we're going over all of this information. We'll give you a chance to interact with us and you can ask your questions. We go into breakout rooms, and at that point, there's typically 3 or 4 people in there. We go into a breakout room for 15 minutes. Everybody reads the script to each other. We critique each other, and that will get you prepared to going and standing in front of the city council or the county commissioners. So, but I cannot respond individually to everybody's message, and Tanawah cannot either. So if you want to be part of the Zoom training, please just take the initiative to go. I will pin this Zoom link on my Facebook, and I'm going to count on you guys to put in your calendar 8:30 Eastern on Thursday, 8:30 p.m. Eastern on Thursday, and then just show up on the Zoom. We'll all be there. We've had as many as 50 people on it at one time, and it was great. So that's it. I think there were a couple people on TikTok that were asking about that. I hope you guys heard it. So I'm done. I don't like talking in front of cameras. Are you ready?
All right, so city councils, that's the reason why we're incorporating them. They pay the police, and they have to make a decision then, right? Every public official is having to make a decision now. Which side of law they want to be on. Do you want to be on the side of the lawful side, or do you want to be on the unlawful side? Because any act unlawful does not produce a lawful outcome. So if what you're doing is unlawful because it's not full of law, right, because it's in violation of the supreme law, then what you're doing is unlawful. And anything unlawful is a crime. So if you're paying police officers to go out and commit an unlawful act, then you are complicit in that crime, right? It's as simple as that. Same thing with the county commissioners. So we need to go out and we need to inform them. We need to notify them on the record that this is what they're doing, and let them decide which side of the law they want to be on. Uh, 8:30 Eastern on Thursday is the Zoom. 8:30 Eastern. So again, tomorrow we're starting back out. We're heading back west again. Like I said, we're going to try to hit as many cities as possible. The problem is that a lot of these city council meetings are on Tuesdays and Thursdays. There's never any on Fridays. Some are on Mondays. There are a few on Wednesdays, but not very many. So it's going to be, we're not going to be able to do it every single day. All right, we're going to be really limited in this, so we're going to try to get the biggest bang for the buck. But another thing that I can tell you guys is that typically the city council and the county commissioners are on the same day. Okay, so whatever city you're in, let's say it's, Denver. The same day that they hold a city council meeting, they'll probably be holding a county commissioner meeting that same day, because they're scheduled on the same days. So you can double up on the same day, okay?
I just had an idea. So I'm going to put a link. I'm going to create a PDF, and I'll put it on the Google Drive of the Zoom link. So that way you don't have to worry about going to my Facebook and all of that. So I will upload that tonight. So the Zoom link will also be on the Google Drive along with the script and the notice that you can provide. So all of the information will be there. So that's justicewithoutlimits.org. Same thing as my TikTok handle, justicewithoutlimits.org.
Yeah.
That'll be easy to remember.
Yeah. And guys, I see some statements here. You don't have to be an attorney to make these statements, guys, because the Constitution is self-evident, right? We all know from the Declaration of Independence, we hold these truths to be self-evident, right? Self-evident. Now, per se, crimes are defined as crimes that are self-evident. So we can show the evidence of the highest form of law by ourselves that these crimes are being committed. These city councils and county commissioners, they don't know that these crimes are happening. In fact, up until this point, the majority of them are going back to their county attorney and saying, "County attorney, is this valid?" And that county attorney is telling them no. And they're choosing to follow someone that is a criminal, right? That claims to be an expert in law, and yet they don't understand the basic concept of legal hierarchy, of lawful hierarchy, right? So you guys are able to do this. Anybody can be heard. That's why there's a public hearing at every city council, because you have the right to be heard by your representatives. So what you do is you go into your, to your city's website, right? Let's say it's the city of Denver. You go to the city of Denver, right? You'll go to county commissioners. You'll go to meetings and agendas, right? Or something along those lines. You'll click on it. There will be a calendar. And it'll tell you what days they meet. They usually meet. A lot of the bigger cities meet every single week. But some of the smaller cities only meet twice a month. And then what you'll do is you'll go into the agenda. You'll open up the agenda for that meeting. And in that agenda will be a whole bunch of items. There will be a consent agenda, a non-consent agenda. There will be adjournment. There will be roll call, all these different steps. But you'll look through each one of the items and you'll find public hearing, right? Public hearing. Because by law, by federal law, they must provide a public hearing, okay? Now, you want to be careful because sometimes the public hearings only allow you to talk about the specific agenda items. But most of the time, they'll have two different public hearings. One will be for agenda items and one will be for non-agenda items. Now, they might ask you to register, right? They might say, well, yeah, you need to register ahead of time. And if you have to register, that's fine. All you can do is put your name, your address, and then when they say the details, you'll just say providing notice in accordance with Rule 20 or the USCS Rules of Civil Procedure and Rule 17, Rule 20 of the Supreme Court, providing notice to the council. That's all you got to say. We're just providing notice, okay? So, but you need to remember, guys, that you're not going in there confrontational. You're not directing this toward any specific person. You're putting something on notice, right, on the record so that they can make the decision what they want to do, right? So you're not cussing them out. You're not telling them that they're criminals. You're saying, hey, this is what the law states. You guys are paying someone to act unlawfully, and now you need to decide if you want to be a criminal yourself. And if you do, then continue doing what you're doing. And therefore, criminal sanctions can be brought against you. But if you don't, then you must stop paying for these crimes to be committed, and you must direct them to act lawfully, right? So, listen, we can't prevent them from exercising their power. We can't do that. But what we can do is we can draw a line in the sand, and we can show them that they're operating outside of the law and give them an opportunity to decide which side of law that they want to be on, right? Because that's a decision that they have to make. And if they're going to make a decision to act unlawfully or continue to act unlawfully or to continue to follow people that are claiming to be experts in law and yet they don't understand the law, then that is not going to mitigate their culpability in it, especially after having provided them notice with their criminal conduct, right? So you'll go into the agenda, you'll look for the public hearing, right? And then you'll be prepared to speak at that time. And usually, if you have to register, right? If they ask you to register, then you'll register, and then they'll give you, a number and so on. And they'll call you up. But otherwise, the public hearing is open, right? The president or the chairman or the mayor or whoever it is that's leading the meeting, he'll just say, okay, once the public hearing is called, they'll say, is there anybody from the public that would like to speak? And all you got to do is stand up and walk down the lectern and say, yeah, I do.
But you guys you have to move really fast sometimes, because if there's nobody moving, they will cut it off in just a few seconds.
Yeah.
So as soon as they say it, you better be jumping up front.
Yeah, yeah. They don't like public hearings, but by law they have to do it. So, you know, and once again, the good news is that as long as you guys aren't cussing, as long as you guys read the script, nothing can happen. And they can't even respond, they can't even reply, they can't say nothing but let you speak. So you got 3 minutes. You read the 2-page script that we prepared, you get through it, and then you say, I got a notice to put on the record, and you go give that to the clerk, and you're done. You're done.
And some of them will have a recording, but some of them won't. So you want to go ahead and look and see if your city councilor or county commissioner is actually recording the public comments. Because when we were in Columbus, Ohio, if it wasn't for me recording, you know, from my angle, we wouldn't have had a recording. Everything was recorded and everything was public except for the public comments. So you might want to go ahead and check before you go and make sure that all the public comments are still available later. And then I want you guys to tag me in this, or tag Tanawah on this and send it to us, and I already have a template. So Crystal Salazar, Melissa Frint, I'm working on her video. We want to create what you guys do and put it into our format and then blast this across social media. So once we cross this threshold of 2/3 of the county / city council, we should have over 100 hours worth of 3-minute videos of these people that are paying other public officials to act unlawfully against us. We'll have over 100 hours of evidence that these people have been provided. That is the end goal. That's the end result. So we need you guys to make sure that you're tagging us or sending me these videos however you can, Google Drive or whatever. So there's that.
Yeah. So someone said over here, don't register if you're banned. Guys, don't put yourself into a situation where you might get yourself into trouble. But we don't want anybody in trouble. If they're preventing you from coming into a city council meeting, then go to a different meeting. Go someplace else. Don't put yourself into a situation where you're gonna get arrested. You know, even though they don't have the authority to arrest you, we get that, right? I'm not saying that. I'm saying that just as Sun Tzu said in the book The Art of War, one who knows when he can fight, when he cannot fight, will be victorious. Okay, so right now, if they had the power and if they told you don't come in, don't go in, right? Live to fight another day, you guys. All right, don't do that. Don't disguise yourself and go in. That wouldn't be a good decision either, because if you do that and you get caught, you're going to be sitting in jail, and there's nothing we can do about that until we get the power back. But you don't have to go to your city. You can go to any city. Hell, you can go to any state, you know, because this can be done in any city council meeting, and the narrative doesn't change. It doesn't change no matter where you're at, no matter you know, it's not unique to you, it's unique to the common issue that they're doing across the whole country, right? So, you know, if you can't go into a local city council because you've been banned or whatever, then drive over 2 cities over and go to that city council, right? Because you're not banned there. But don't get yourselves into trouble. We don't need a bunch of people in trouble. I need you guys on the front lines with me. I need you guys ready to go. You know, when this actually starts. Okay, we need you guys out and not sitting behind bars. Okay, all right. You're still friends with Phoenix Kai?
I just blocked her.
She's an idiot.
I didn't know.
That's right. Okay, guys. So we got city councils, we got county commissioners. If you guys want to do the service again, you'll go to justicewithoutlimits.org. Justicewithoutlimits.org. You download the paperwork there. Over the next 40 days, it's going to be critical that we get as many of these done as possible. All right, we need as many as possible, because this is when we're going to make the most noise right now. Okay, we've already served the attorney generals. All the prosecutors are served. Don't got to worry about them anymore. We've already served the Supreme Courts. All the judges are served. We don't got to worry about them anymore. All we got to worry about now is the legislative branch and getting as much done as possible between now and the Supreme Court returning from summer recess. So Scripture said, it says, how do I describe this current generation? They're out playing in the park, right? They're like a bunch of children out playing in the playground. Well, we got the Supreme Court and Congress out in recess right now. We got them out playing in the playground. Let's go ahead and bring this destruction upon them while they're out playing in that playground, just like Scripture says, okay? Let's do that. All right? Because we can. By the time they come back from this summer recess, we want so many people talking about whether or not they're acting lawfully that Supreme Court of the United States will have no choice but to hear the case, not ignore it anymore, and make this decision, right? That's the whole point now. If you guys want to help see us get going and keep going on the road, again, please donate. All right, we only have 40 days before Supreme Court comes back from this summer recess. So if you guys want to keep us going, then we have Cash App, Chime, Venmo, PayPal. You guys know these are the only ones that I have, guys. I don't have anyone else. No other Cash App, Chime except for We Shall Be Free. If you guys donate to any Cash App, Chime, Venmo, PayPal, if anyone messages you and asks you for money, it's not coming from me, because I don't ask for you guys. I don't send messages to you guys. This is a self-donation process, okay? I'm not actively soliciting you for money. I'm simply saying that if you want me to continue to serve you, and if you like the service I'm providing, then you guys need to make sure that I have the resources I need to be able to accomplish it, okay? So as of this moment, right, I'm going to tell you that we got about $250. It's not very much. It's not going to get us very far, but we will continue to go until we have no more money to go. If you guys want to see us continue to go, then please get out and donate. Make sure that we have resources. We don't need much. We need gas, we need food, and we need a place to sleep at night. That's it, right? That's it. That's all I've ever needed, right? And so if you guys want to help see us continue to do this, we have Cash App, Chime, Venmo, PayPal, and they're all exact same. It's We Shall Be Free. It's WESHALLBEFREE. We Shall Be Free. And I want to set some expectations here, okay? All right. First off, we're not going to tell you where we're going to be. All right. We're going to allow God to lead us every single day. We're going to wake up in that morning and we're going to say, okay, what is within driving distance today? And that's where we're going to be. All right. I'm not going to be coming to anybody's particular city, right? I'm not going to be coming. If I come to your city or your county, it's just because God led me to that place. But we're going to allow God to lead us every single day, every single step. And there are absolutely states that we are going to be hammering. California, you can expect to see us there. Mississippi, Louisiana, Alabama, Florida. You guys need our help. I know it, right? We're going to be there. Michigan, Minnesota. We know you guys need help. We're going to hit as many cities as we possibly can. All right. But just know that what we're doing now, we aren't going to be providing any advance notice on it. Okay. Because this is the time that's going to be the most dangerous of all, because now we are messing with their money. Once you start messing with their money, that's when people get pissed off. All right. Arizona, we will be there. We'll be in Arizona. I can't say where, but each one of these cities, again, just because we don't hit Phoenix doesn't mean that Phoenix isn't on notice because we serve Flagstaff, right? I mean, as long as we serve a city within the state, then the legislative branch has been served. Because again, notice to agent is notice to principal, but notice to principal is notice to agent. So me not coming to Phoenix, hopefully we can get people in Phoenix to actually get out and serve, because the more we serve, the better. But I'm saying for me, just because I don't come to Phoenix doesn't mean that the service to Flagstaff is not going to be sufficient. Okay. And what else?
Just Thursday night at 8:30 p.m.
All right.
on Zoom. Because we want people to be comfortable.
Yeah.
When you go, so.
Well, I'll tell you guys, I'm not even comfortable either. You know, when I walk into these meetings, I'm not comfortable either. I don't like doing what I'm doing, but it needs to be done. Maine has been served. We served the Attorney General and the Supreme Court. I can't say that we will necessarily be there again on the legislative element, but they are absolutely incorporated and enjoined as a state. But Maine's a long ways up out of the way. We want to be back in D.C. that first week in September. We need to be back in D.C. that first week in September. All right, so that gives us what, two months? So about 60 days. We'll go as many places as we can, but it's all going to be dependent on funding and budget. But also bear in mind, you guys, that we only have really 2 days a week that they have these commission meetings. Tuesdays and Thursdays are typically the only days. We will be looking for something to do every single day, but I can't guarantee that we'll be able to find something. So, and again, when you go in, just know that I'm nervous too, guys. As you guys will notice, like my mouth gets really dry when I start getting nervous, you know, and so then I have a hard time. Your tongue gets heavy, and you know, and stuff, and it's not an easy thing to do. So I totally understand, you know, what challenges you guys are facing, but we need to face those fears, and we need to overcome them, because this country needs this help, guys. They need it, right? We understand the true oppression that exists within this nation because of the deprivation of the fundamental principles and rights to people. We know that. We get that. And so, sorry, I was reading over here. We know the oppression that exists, and we know the urgency of what it is that we're doing. So I know that people are nervous, but we need to face that fear and do it, because this country needs it. All right, we're not going to have a country anymore if we don't make this happen. All right. All right, guys. So again, justicewithoutlimits.org. You can download the 2-page script. All you got to do is just insert your name, your state, and read it the way it is, right? Don't add anything to it. Don't take anything out of it. And then also you can download the 4-page notice. And so you'll read the script, get through it, and then you'll say, I got a notice that I want to put on the record. You'll take that over to the city clerk, give it to the city clerk, and you're done, right? Same thing with the county commissioners. There's a slightly different verbiage, because we did add sheriff into the county commissioner, because that's key. The county commissioner would sit there and say, well, we don't pay the police, you know, so we got to add sheriff into it. So there's a slightly different one, but you know, nonetheless, just understand that they're basically the same thing. We just added a couple small things to it. And so then get out there and find the dates. Relay those back to Jessica here, please, because so that she can keep track of what's been served and what hasn't been served. Some people have asked for that. We've got some spreadsheets together and other things. So get the information back on where you're serving. If you got the video, get us the video. And other than that, guys, together we shall be free. All right? Anything else?
Nope. See you on Thursday. That's it.
All right, guys. Thank you so much. Get out and donate. And we'll be on the road tomorrow. And I can't wait to see you all out there on the road. All right, guys. Thank you so much. Have a great rest of your night, guys. I'll respond to these. I'll look through them all and we'll respond, all right? Thanks, guys. Thank you. Thanks, YouTube.